Okay guys, here we go. No! That's my 4-year-old son Liam, and this is one of the cool things they do at the university. They will teach your kids to swim. These are actually kids on the swim team, which is a nationally ranked swim team, and they will teach your kid how to swim, and he's having a great time because at the end of it the reward is they get to jump off of the board, and he had a good time. So one of the things that I like to encourage faculty, research faculty, any employee of the university is get in the pool. In other words, technology transfer is kind of this funky thing that we like to talk about. Really, the way I like to see it, truly, it's a service. It's very interesting to me, though, that we start off the day with our chancellor talking about increases in licensing and options and patents and return to the university, and then we have another discussion about shouldn't we be giving this away for free? We would attract much more industry-sponsored research. If we gave the classes for free, I think we might get more students. Maybe. I don't know. There is MIT open course program. We can talk about accreditation. We can talk about all that stuff. But I do think it comes down to valuation and what you want to return on. And do you want a return? And by the way, technology transfer historically has not been that great of an effort to earn a return. It does start with the research. It does start with the industry contact. And it does start with a constant effort. I see it more as a service to the university, and it is a call to get the technology off the shelf and used and useful. Back in 1980, there was an act called the Bayh-Dole Act. And basically, it said the universities could take ownership of federally sponsored research. And they also wrote into that that companies bringing that sort of research to the university could not force the university to give up their rights and to take it for free. And the reasoning behind that was because they found that university research was getting old and musty on the shelf because there was no competitive advantage, because the university would give it to anyone. So as the industry competitors came, the university gave them each the technology. Where is your competitive advantage? There isn't. Why would you switch to digital from analog? I don't have to. I'm a monopoly. Take what I give you. Well, then all of a sudden you have some regulation that says, no, you're going to have to switch to digital. And then they did it. So what we would like to do is in some ways create a value stream, and so that you can actually have a return. It is supposed to be a circle, a return of research dollars to the university so you can continue that effort. Okay, so I can hold this discussion in any way you want. I have kind of a canned presentation that walks you through patents, trademarks, copyright, street secrets, and mask works, but we can also just talk about my general feeling as a senior licensing person how technology transfer is supposed to work, and if it does. I am a patent attorney, so I am welcome to talk to you about anything in intellectual property. To do that in 10 minutes is fun, but we can also talk about technology transfer. Who wants to talk about patents and intellectual property in general? Or has everybody had that knowledge? Anybody? If you do, it's okay. Patents, 20 years from date of application when it was filed. You only get the patent protection in the country that you file it. You can file a PCT, which is a patent cooperation treaty. It gives you 30 months to enter into member nation states, some 220 of them. But again, each one is going to cost you. In the U.S., we tell people it costs about $8,000 to $10,000 to draft the patent application. Over the examination of that patent, you're going to have several office actions, and those are going to require legal argument. Most of the people that I hire to deal with the university mentions I manage the process for the university. I don't act as an attorney for the university. They have their PhDs and their sciences. They've also gone to law school. They've also passed the patent bar. These are very expensive people. They charge about $350 an hour. And so I ask them to cap their rate. And I also say be a good alumni and give us a cheap price. And they usually do. And we have a good working relationship, and you can see we've been successful in getting that. sometimes even on the first blush, which is somewhat rare. So we thought enough of this that we actually put it in our Constitution. It's not just a law that has been passed, there are patent laws, but we have it in our founding document that we will promote the progress of science and the useful arts by securing for limited times to authors and inventors exclusive rights to their respective writings and discoveries. Now, here's the very first one. It was signed by George Washington, and it still is an engineering function, making potash and pearl ash by a new apparatus and process. So, way to go, engineers. So we like to have people really start at the idea stage of it. Is that if you have an idea, even at the idea stage, we want you to be thinking about technology transfer, about how to get that from the university out into industry. Sometimes and it's not the most general case, but sometimes you already have industry involved with you. We actually find through the Association of University Technology Managers that about 70% of the time the inventor has already made contact with a potential licensee. And that's because you're the one giving the talk, you're the one giving the presentations, and at the end of it, Boeing comes up and shakes your hand and says, I'd really like to know more. I'm not there. The inventor is there, and that's how they get the contact. So this is really aimed at graduate students and researchers. You can see the invention, you determine who contributed to the invention, so who are actually the inventors. And then my job really starts with the Invention Disclosure. And we have gone to great lengths at this university to shorten that process and make it easy as possible. In fact, if you call me up and you have a paper draft and you staple it to my form, I've been known to fill out the form for you. I also think this is a great exercise for graduate students, as this is exactly what they're going to have to do when they go to work for Boeing. By the way, Boeing puts a little sheet of paper in front of you, even if you're the janitor, and it says, I own your brand, and you must disclose to me, and I will incentivize you, but all I really owe you is $1.
Does technology transfer also look at that level community, or just in...
I do, because we are knowledge dissemination. We're a university. I help in an educational capacity. So if you come into our office, we also have a small business development center. And what I do is I educate you. So I cannot legally represent you. I had to sign a piece of paper that says I won't represent a university employee or university technology. I do represent members of the community outside of work, but not in my job. So, what I do, I perform patentability search, and in some cases, this kind of see this is what I do. This is very collaborative. In other words, I have not spent the last 2 years of my life dealing with this technology. The inventor has, but I also am trained to think about things differently in a legal fashion, and search through that. So I try to do a patentability search, and I work with the inventor, and a lot of give and take. Here's what I found. Oh, you're totally off track. It's not that, and then I share back. And sometimes we can't find anything, and that leads to patentability. And sometimes we find exactly that thing, and then we have to say, sorry, it's going to lack a novelty, or you're going to have one heck of an obviousness argument. We'll talk about that. But then we work it through the prosecution. I file. Or I have filed copyright provisional and full utilities. So our office actually manages that. We have a budget to do that, and we can work with you. We also work through notice of allowance, payments of issuance fees, protecting, defending the patent. We seek the commercial licensee, and again, it's a collaborative effort. You're the one that usually has a network much more attuned with the potential licensee. But we actually enter and negotiate those contracts, such as options, NDA, and license agreements that you've heard about this morning. And then we manage that process, also collecting the royalties, which you might what? I don't know. Let's see. So how long does this take? Generally, you get a 20-year period of exclusion from data filing. Now, I don't like this slide because it shows ideas is really, a simple process. This idea thing is way back here. and then you actually have a publication after 18 months of submitting your application. So the best researcher, the best searcher in the world for prior art has an 18-month dark period. They don't know what's been filed in the last 18 months unless someone has published a paper or put out on a website. And yes, I do look for those and I try to find them. This process can take 2 to 3 years. You might lengthen it to 4, depending upon the group unit of the examiner. And I am rushing through these because I was told I had 10 minutes. Requirements for patentability. It has to be statutory, it has to be novel. This is the big one, not obvious, and this was the change in law that we are now a first to file. We were a first to invent March of this year. We went to a first to file system. And of course I talked usefulness, not a big barrier. This is a watch that your dog can tell how old it is in dog years. And yes, it was patented. You're not supposed to reinvent the wheel. Now this is huge. If you're in patent law, you're scratching your head and your jaw is dropping. But the claimed invention was patented, described in a printed publication or in public use on sale or otherwise available to the public for the effective filing date of the claimed invention. This is the new law that just went into effect. It used to say in the United States. It no longer says that. So all the pundits, and I did my search and went out, and the very expensive people that we hire say this has exploded the definition of prior art. Literally to the world. You are now compared against the world. If somebody in Uzbekistan put it on the website, guess what? Prior art. And if you know about it, you must submit that in an information disclosure statement to the examiner or commit fraud. So again, this is why you have a technology transfer department to help you understand these things, to look for that IDS and to fill out all that information, and also just come to an understanding of what is prior art. In the United States, we still have a grace period. This really ticks off the rest of the world. The rest of the world does not have this. So as a professor, let's say you get up and you talk about your paper, you really submit enabling information about your invention. To the rest of the world, you're done. Cat's out of the bag, public domain. In the U.S. and U.S. only, you have a 1-year grace period from that dissemination of enabling information. I didn't use the term publication to use that messes with people's brains at a university. Dissemination of enabling information, you have a 1-year grace period to enter into a patent filing for U.S. protection. The rest of the world says it's in the public domain. Now, if you had filed provisionally, it's a placeholder application for a full utility application, patent application before that, you're still good. So this is why we encourage you to disclose, and then you tell us, hey, next week I'm off to Pittsburgh and I'm going to give a conference. We can say we can file provisionally tomorrow and get you some level of protection before you go talk. We can do that rather economically. But I'm also not supposed to stop you from disseminating information. We're a university. That's why kind of when industry comes in, they say, oh, we want to keep this a secret. I kind of chuckle. You know where you are. Also, sometimes there are national, there are secret things that we have, and I don't even get to see this. So you have to be a true inventor, and again, it's just not something, we have somewhat of a difficulty with this at university. We think that because everybody was in the room, we're all inventors. No, we have to look at who conceptualized the solution. Sometimes we say, oh, my grad student who did all the hard work is an inventor. No, not unless they put their brain to it. If they just did what you told them to, they don't rise to the level of inventor. Now you also have to be careful because if they did put their brain to it and they helped you, they are. And you must put them on. It is a legal definition of inventorship. First to file, so there's a bunch of lawyers at the starting line, and we're taking off. Still, even though we're not a first to invent, please do your lab notebooks, and for students do your lab notebooks. We still need to show that inventorship. Still, that first in time may save you from infringement. Please definitely keep up with that process. Not obviousness. Now, you have an inventor that's taken 2 to 3 years of their life. They know what's out there. They know what's in the scholarly literature. Guess what? You're going to have a rejection on first office action of all claims based upon obviousness. and it makes people crazy. How dare you, examiner, say that? The examiner's trained to do this. They're trying to build history. You've asked for 4 property corners in your claims. They're just saying you aren't deserving of that. You're deserving of a little less property. And that's the argument. It becomes a legal argument. And there are ways to overcome that obstacle. That's, again, why you have that expertise and effort. Patent ownership. You have a UM system rule that says all employees of the university have a duty to assign to the curators of the university. What it says. Now, it also is a little bit more verbiage than that. It also talks about the scope of the work. And what we encourage people to do is to come in and talk to us about whether they should disclose. And there's also this question, well, I was consulting last summer. Does the university have any right to come in and talk to us? There may be a question. And where you don't want to have that conversation is after you file a patent and you're off working for a company and you're starting to make money, and then all of a sudden somebody at the university says, didn't you write a paper on that? Didn't you put at the bottom that NSF helped you fund this? Ooh, that's a problem. So, okay, this is a little bit old, but again, I'm sure you've all read patents. Google patent is an awesome, amazing thing. It's something as a young attorney would have cost me multiple thousands of dollars to have to see that. Now it's all free. It's cool. I've found some problems with the machine translation though. Had some problems with French and German and things like that. So be careful. We have a recent change, fairly recent, change in the rules. And I get this question a lot from undergraduate students. Will the university take ownership of my invention? And here's the interesting thing is a lot of times they want the university to. Because we have things like budgets, we have attorneys. We have all this cool stuff that we can make things happen. But the answer generally is no. We no longer take an interest in an undergraduate invention. Now, that is if they aren't paid by the university to actually do that research. If you have someone in that role, we might, or if they take extraordinary use of university property, so if someone wants them in the reactor or use some specialized piece of equipment. Okay, and I see some people buzzing around the door, so I don't even know how much time I have. But anyway, this is a question. Now, if you have a graduate student and they're being paid, they likely are considered a university employee and must disclose. Okay? Now, if you have a graduate student that's not paid, it creates a question. Come in and talk to us. Copyrights, I file these. Where the university is going right now is we are really trying, especially at this university, to try to encourage people that it's not just the invention, because so much of it relies upon that stuff, right? The computer. So everybody comes up with a new process or way, but then they have to feed it into a computer. Well, where's the code? Oh, there's this something else. No, the code has a value. In fact, when you go out to industry, they'll say, how do you run it? And sometimes we say it's in the math lab, and they're like, oh, can you write it in something else? Well, yeah, we can, and we can actually give you the software and allow you to massage it. We can do those agreements. And by the way, the big guys at Stanford and MIT, they're used to this. They'll actually have it on the front page. You want a license, here you go. We're catching up. So again, these are my responsibilities. We assist faculty and students in business startups. It's somewhat of a tough sell because you do have your 9 to 5. You do have a limited ability to do even more research, especially even looking at grant programs like the Small Business Innovation and Research Programs. But we are definitely wanting to have those conversations. We are wanting to even hear what you were saying about the limitations, because we can kind of spread those talking points around and see if we can come to a solution. And there I am. This is my director, Keith Strausner. I'm Eric Anderson. Barry Anderson is our relation. She's in our office, and you can come talk to us about just about anything. So, questions?